we take those into account in our disposition. With that, we'll call the first case.
The first case involves Neil Heimbach and Karen Falalaski versus Amazon.com. Arguing on behalf of Heimbach is Peter Weinbrake. Arguing on behalf of Amazon.com is Michael Kennelly.
Good morning again. In this wage and hour case, brought under the Pennsylvania Minimum Wage Act, the question presented concerns whether Amazon warehouse workers are entitled to be paid for time they spend being screened for theft prevention purposes at the conclusion of their workdays. Weinbrake.
Thank you, Your Honor, and may it please the court. I'm Pete Weinbrake, and I'm pleased to represent Neil Heimbach and Karen Falalaski in this case. The certified question asks us to reflect on the value and dignity of work, types of workplace activities, and what amounts of time are worthy of compensation under Pennsylvania law. The first question asks whether hours work includes, quote, time spent on an employer's premises, waiting to undergo and undergoing mandatory security screening. Amazon says no and trivializes such time as not entailing labor or toil. But why should we accept Amazon's value judgment about a worker's experience in the security line? Can it really be said that waiting in a security line in a hot warehouse after a full shift has less value than the work of a corporate executive? Mr. Heimbach and Ms. Falalaski say no. There is dignity in all work. Chevalier, Beata nurses, and Justice Todd's Chiarelli dissent teach that the PMWA is remedial legislation. As such, its hours worked definition leaves no room for Amazon's subjective value judgments. Indeed, the definition is entirely objective. Hours worked includes, for example, time in which an employee, quote, is required to be on the premises of the employer. As such, the first certified question answers itself. The second question also concerns the value of work. Amazon claims that even if security screening time is legally compensable, the worker should nonetheless go unpaid because such time is de minimis. But why should hourly warehouse workers, rather than Amazon, bear the financial brunt of Amazon's unwillingness to credit small amounts of time? None of this can be squared with the PMWA's language, which explicitly mandates pay for, quote, all hours worked. Nor can any of this be squared with the law's remedial policy goals. In addressing this issue, the Sixth Circuit also seems to expect that this court will address the applicability of Portal Act Section 4 onto the PMWA. In this regard, there's a very important point that Amazon would like, that appellants would like to point out, and it was made very nicely in the excellent amicus brief that was submitted by the AFL-CIO and NELP and Philadelphia Community Legal Services and other organizations. We need to be very careful when we graft Fair Labor Standards Act principles onto our state law. And the reason for that is because when we pull federal principles into our state law, we're not just grafting onto state law the language of the FLSA statute. We're also bringing into the state law a whole body of regulatory and interpretive guidance issued by the Federal Department of Labor. That includes administrative opinions, opinion letters issued by the Department of Labor. It also includes a whole body of federal decisional law from places like the Fifth Circuit Court of Appeals, the 10th Circuit Court of Appeals, And the one thing that all of this federal interpretive guidance that surrounds these FLSA provisions is Pennsylvanians have no say. The federal courts and the Federal Department of Labor interpret these FLSA provisions.
The way I see it, you're asking this court to rule those who choose not to use the lockers should get more money than the same employees who choose to use the lockers.
Well, Your Honor, the reason for that is because Amazon has put in place a baseline mandatory anti-theft security requirement. In other words, every single employee in the Briningsville warehouse, regardless of whether he or she uses the lockers, has to go through security screening. Now, Amazon claims, and appellants do not dispute much of this, Amazon claims that by using an express line, one could get through that process more quickly. Even if we assume that that's true, the employee that uses the express line still has to go through a mandatory security screening. So the issue that I think that Your Honor raises is not an issue of compensability. It's an issue of damages. In other words, the person who uses a locker gets to use the express line every time. The data may show that that individual gets through the process in 2, 3, 4 minutes. The individual that can't use the express lane might take 7, 8, 9 minutes. But it's a question of damages, not a question of compensability. And I would submit to you, Justice Doherty, even an employee that can get through that express line in 2 minutes. Let's take Mr. Heimbach, for example. Amazon concedes that Mr. Heimbach worked for 494 shifts. Even if Mr. Heimbach went to the express lane every single day, and let's assume it only took 2 minutes, that would add up during those 494 shifts to nearly 1,000 minutes of uncompensated.
Counsel Justice Mayor, and in deference to my colleague, Justice Doherty, I wanted to interrupt you because it seems to me that you're off base in terms of the response, and I want to clarify something. I thought we were on summary judgment. On summary judgment, the plaintiff gets the benefit of the facts as pleaded is true, unless contradicted, and your pleading was 10 to 20 minutes. And that's why I didn't think that the second issue was really in the case. It may be in the case later on. And so I wanted to ask you, has Amazon filed affidavits contesting the 10 and 20 minutes? Is that in controversy in this summary judgment motion? And then go ahead and respond, finish your answer. But I'm just curious what the facts are that are before us.
Yes. One important thing to realize, Justice Baer, is when this case was first pled, the plaintiffs were not only seeking compensation for the end of the shift, they were seeking compensation for having to go through security during the lunch breaks. And that is one of the reasons why the pleadings were up into that range of 20 minutes. We dropped the lunch break claim. So now we're just talking about the end of the day. So what our data shows is that the average amount of time it takes to get through the security screening process at the end of the day is around 8 minutes. That's what the data shows. So the way that we know that, Justice Baer, is because before an employee in the Amazon warehouse enters the security process, he or she clocks out. So we have that data captured. And then when the employee gets through the process and leaves the warehouse facility, that employee has to go through a turnstile, and that creates another data point. The average gap between those data points is 8 minutes. The parties dispute. Amazon does not concede that that entire 8-minute average is attributable to the security screening process. And that's going to be a question for the jury someday. However, appellants will certainly argue that Amazon has no one but itself to blame for any for the lack of data because they are the ones who control the process. And really, when we look at the de minimis, the de minimis principles, that's very important, I think, to keep in mind that Amazon controls this process, and the workers should not suffer for Amazon's unwillingness or inability to track the data. We're doing the best we can using the 2 data points that are available to us.
Well, and again, I think you're down the road procedure a little bit. 8 minutes is where you are. With that, would you be nice enough to continue responding to Justice Doherty, who, just to get you back on track, asked you to distinguish between employees with lockers who can bypass the process altogether and employees without lockers who can bypass the process substantially? Because I didn't mean to interrupt. I don't want to interrupt that answer.
Yeah, and on that point, my main point is that it's an issue of damages and not compensability. Secondly, however, Justice Doherty, I just want to emphasize how disputed, and to Justice Baer's point that we're dealing with the summary judgment record here, where all facts should be construed in favor of the non-movement, my clients. Plenty of evidence in this record that those express lanes that individuals went through when they used their lockers were not as express as Amazon makes them out to be in its brief. We have to remember, these are giant warehouses. There could be hundreds and hundreds of individuals leaving the warehouse at the same time. And in the reply brief, I provided the court with a block quote from some deposition testimony where Mr. Heimbach says he observed the express lanes on a daily basis, and the lines were really, really long. Ms. Solaski also has deposition testimony that's in the record where, and Ms. Solaski, by the way, often used the express lanes. She has deposition testimony in the record that about how long those lines can be. And in fact, the data shows Ms. Solaski occasionally it taking her 10 minutes or more to get through the process, even though she was using those express lanes. So one of the frustrations, I think, at least for me, has been, we're here on these issues of law that have been certified by the Sixth Circuit. And I was troubled by the extent to which Amazon tried to cherry pick the record in the opposition brief. And I tried to confront that in the reply brief without going too far down the rabbit hole. Have I adequately answered your question, Justice Doherty?
Thank you.
Counsel, on the Justice Baer again, I'm sorry. On the second point, whether this is de minimis. First, I don't know that Pennsylvania has a de minimis standard, but I'm curious because you began to go, to that saying, well, 2 minutes is de minimis because if you, I suppose, multiply this out times the number of days worked on the number of employees, it's a lot of money in a class action setting. Have you thought about what would be de minimis? Assume we have a de minimis standard. If this was a 15-second water fountain break and that they weren't paying for it, would that be de minimis?
I think when you look at the California Supreme Court's Troster case, they came very close to eliminating the de minimis doctrine in California, but they didn't open the possibility that time could be de minimis if it was truly insignificant. So talking about Your Honor's 15-minute water break, the answer to that would be no, because a water break would happen within the context of the workday, and we don't try to turn on, using the water fountain metaphor, we don't try to turn on and turn off the compensable time spigot every time someone takes a 15-second break or a 1-minute break. The idea is we pay individuals from their first compensable act till their last compensable act. Another practical point I would make to Your Honor is, for a claim to actually get litigated, a plaintiff's lawyer has to actually be willing to take the case, right? And when we start getting into 15 seconds, 30 seconds, 45 seconds, there's simply not any lawyers that are willing to take those cases. Even though in Troster, the California Supreme Court essentially eliminated the de minimis doctrine, it's not like we've seen some onslaught of lawsuits in California seeking pay for insignificant amounts of pay. Also, to answer your question, though, Your Honor, I think that the court could just flat out eliminate, make it clear that there simply is no de minimis rule. The statutory language is clear. Workers are entitled to be paid for all hours worked. And this is the alpha and omega of the Pennsylvania Minimum Wage Act. It's a precious concept. And I think the de minimis rule just simply cannot be squared with that public policy that underlies our state statutes.
Justice Todd, did you have a question?
It was answered. Thank you.
Thank you. Okay.
Justice Bear, Chief, one more. And I don't even know if this bothers me terribly, but you were arguing that we should not use the FLSA as guide to Pennsylvania. You have a narrower street question here, it seems to me, which is whether we should engraft into Pennsylvania the distinct, separate Portal Act. And I think that may be a different analytical framework. But isn't it true? I thought I read this in my preparations, that we modeled the Pennsylvania Minimum Wage Act after the FLSA, and we in fact look to it generally for interpretation. Or is that inaccurate?
That's inaccurate, Your Honor.
Okay. Thank you.
First, should I go further? Or?
You can explain.
First of all, let's start with Beata nurses. This court made it very clear that the FLSA is merely a floor above which the PMWA can extend rights. And thankfully, in Beata nurses, we were able to apply the PMWA to low-wage home health aides who were not entitled to overtime under the federal law. Then in Chevalier, more recently, this court extended the manner in which overtime pay is calculated using the 1.5 system instead of the 0.5 system, again, extending our law beyond the FLSA. There are some specific examples of the PMWA tracking the FLSA's statutory or regulatory language. But as this court noted in Chevalier, that's precisely why when the PMWA does not track the FLSA language, it's very safe to assume that that was a deliberate choice by the General Assembly. And that's what we asked this court to do in this case. And it's what the Sixth Circuit did in the Busk case when it analyzed the Arizona law and the Nevada law, and it's what Chief Justice Frida Wolfson recently did in the Vaccaro case with respect to New Jersey law. And now we ask this court to be the fourth court to decide that Portal Act Section 4 does not apply to a state wage and hour law because it's simply nowhere to be found in the statutory or the regulatory text.
Thank you. That's well answered. Chief, thank you for that last question.
Thank you. Who has a question?
I had
a question.
Yeah, I had a quick question. Hi, this is Justice Clucky. I appreciate your discussion of the Chevalier case, particularly because it's a recent one that has ruled on. But I'm just wondering what your takeaway is with regard to the regulatory definition of hours worked in that the EMWA and the FL, they seem to be very nearly identical.
Yes. It's an issue that's it's addressed very well, I think, Your Honor, in the Sixth Circuit's Busk opinion. And here's what the Sixth Circuit says in Busk. I also think, by the way, the State Attorney General did a nice job of addressing this issue in the Attorney General's amicus brief. The traditional concept of work, the traditional definition of work, was laid down in a series of New Deal FLSA cases issued by the Supreme Court, including Anderson versus Mount Clemens and other cases. That was an extraordinarily broad definition of work. That is the definition of work, that traditional concept of work that the Pennsylvania rulemakers adopted when they wrote the definition of work into our regulations. Then, so this, no one really questions whether post-shift security screenings fit that definition of work. Indeed, the Supreme Court's integrity staffing case would never have even gotten to the Portal Act issue had the screenings not constituted work under the traditional definition of work. Here, our state has adopted that very pro-employee definition of work from the 1930s and 1940s, and then never adopted the exception that was set forth in the Portal Act Section 4. And there's a very, very nice explanation of this whole concept in the Sixth Circuit's Busk case, where they say, this all weighs in favor of the workers because Arizona and Nevada adopted the broad traditional definition of work. Then they never changed that. So that demonstrates a legislative intent to continue to go forward with the traditional definition of work. Judge Wolfson said the same thing in the recent Vaccaro case. So I would submit to Your Honor that the fact that the PMWA's regulatory definition of hours work tracks the definition in the Supreme Court New Deal cases is one of the things that weighs in favor of the plaintiffs.
Thank you. We'll hear from Mr. Kennelly.
Good morning, and may it please the court. My name is Michael Keneally, and I'm arguing today on behalf of Amazon and Integrity Staffing Solutions. I'd like to start with the first certified question because the parties have proposed a number of possible legal tests in this case to resolve whether security screenings count as work. And I want to stress at the outset that none of these potential tests supports counting all time in security screening as work, which is, I take it to be the position that Mr. Weinbrake has offered. And if I could go back to Justice Doherty's question on this, I think it's a very important point. And I disagree about whether it concerns damages versus compensability, because I take it to be common ground between the parties that just walking out of the building, if there were no security screening at all, would not be part of the workday and would not count as compensable. And then the question is, if the security screening adds no time, would that suddenly become compensable? And again, I haven't heard any argument as to why it would. If there's no additional time, there should be no additional compensation. And so really the heart of the matter—
Counsel, could I interrupt? Wouldn't that just, sorry to interrupt you, but wouldn't that be an issue not for us, but for the fact finder? I mean, the issue for us is the question of the compensability vel known, not the quantity of time that's involved.
I don't disagree with that, Your Honor, but the question, I mean, before the fact finder can answer the question, this court needs to sort of articulate the question. And I think here the issue of compensability really does need to zero in on the amount of additional time at most that is attributable to the security screening requirement, as opposed to the time that is attributable to the employee's choice to bring in a personal item rather than use the locker that Amazon provides. And I'm not asking the court to—
Yeah, brief follow-up. Okay. In the Sixth Circuit, you I think you agreed in the Sixth Circuit that 231.1 was applicable. And under 231.1, all the time that the employee is required to be on the premises is included in the hours worked. And so presumably, time required to be on the premises includes the time physically for that person's body to move from the gate to the workplace and from the workplace to the exit gate. And then issues about how much time that is seem to be issues for the fact finder, or what am I missing?
Well, a couple of responses, Your Honor. We did not concede in the Sixth Circuit that the regulation governs. On page 31 and footnote 6 of our Sixth Circuit brief, we disputed that point. But I'm happy for present purposes to assume the regulation applies, because it's important to read the entirety of the regulation, which excludes expressly time spent on the premises of the employer for the convenience of the employee. And that is a direct quote from the regulation. And so here, I think if we're asking what time is required by the employer rather than spent for the convenience of the employee, you have to exclude time that the employee could have avoided if the employee used the lockers that Amazon provided. Otherwise, the implication would be that employee A should receive more compensation than employee B, even though the only difference between them is that employee A wanted to bring in car keys or a pack of cigarettes and then therefore had to undergo the additional screening. And so I don't think that's consistent with the regulation if we are applying the regulation. And it's certainly not consistent with the statute's declaration of policy, which is section 1 of the PMWA, which says that the touchstone for compensability here is the fair value of services rendered. And the employee who is bringing in personal items is not providing any additional service. And so it would be inconsistent with the policy that the General Assembly itself articulated to provide greater compensation for identical services. And really, I have to dispute Mr. Weinbreak's points about how this is somehow about denying the dignity of work, because Amazon does not deny the dignity of work. It is extremely proud of the way it treats and compensates its employees. And in fact, it was one of the first major retailers in the country, and still one of the only ones, to go to an across-the-board $15 minimum wage, which is over twice the minimum wage in Pennsylvania.
Counsel Justice Baer, and you can go off on that divergence, but I hesitated to interrupt because I just like to interrupt in answer to another justice's question. But I have the same sub-inquiry regarding Justice Weck's question, which is we're not post-trial with a factual record that we can delve into. So what are the actual, this is your motion for summary judgment. The other side is correct that they get the benefit of facts inconsistent with yours to the extent you have not contested them by deposition, by affidavit, by something else. So what are the actual facts apropos? And it can be apropos of Justice Weck's question, which has to do with when are you on the premises, and is that, I mean, it's not for the convenience of the employee. I would not think we would interpret it. You can argue it if you want. When you're walking from the parking lot to your job, I would think that's for the convenience of the employer. But I'm interested in what the actual facts are that we have before us in this procedural posture, apropos of Justice Weck's question. Do you follow me?
I think I do, Your Honor. And okay. I'm not going to deny that there is a dispute as to how much time it takes. And I think both sides do agree that it varies from one employee to the next. I think Mr. Weinbreak said, it's at 8 minutes on average, but it may be substantially less if you use the express lane. So there are factual differences between employees, and we're not asking the court to identify the amount of time based on disputed facts. But I think that the principle still remains very important, and I don't know of any case law that supports the idea that the employees' commute from the parking lot to the building would qualify as part of the workday. If that were true, it would mean that the employee who chooses to work on an upper level of an office building should get more time because the elevator ride takes longer than the employee who gets to leave from the ground floor, or the employee who chooses to park in the parking garage would get more time, or the employee who chooses to walk down the stairs rather than take the elevator.
That's probably very fair. I'm thinking about the scenario where there are time clocks, which I think are pretty common in a warehouse, and you punch in and you punch out before you enter the floor. So well said.
Right, and if we're applying the regulation, I think that the right test for the court to adopt would be to look for the incremental amount of time that the security screening itself adds to the exit process. Because I don't think, and I don't think plaintiffs have argued that the time just to walk from the time clocks to the front door is compensable. And so then really we should zoom in on the amount of additional time that the exit process, and this court doesn't have to answer that question. That can be for the fact finder or the Sixth Circuit. But it's really the additional time, and it shouldn't be the additional time that is attributable to the employee's choice to bring in a personal item, because that really doesn't treat employees even-handedly. If a person can sort of elect to receive greater overtime compensation by bringing in keys to the workplace or standing farther back in line or something like that.
Counsel Justice Berrigan, maybe to get us back on track, and I may be guilty of taking us off track, and I apologize. Isn't the narrow issue of law before the court whether the portal-to-portal federal act is applicable to Pennsylvania Minimum Wage Act?
Well, I guess the court could decide that, but I read the first certified question to really ask about whether, more generally, security screening time counts as compensable under Pennsylvania law. And so if the Portal-to-Portal Act does apply, then I think that becomes a pretty straightforward question, because the United States Supreme Court has decided that the Portal-to-Portal Act does not count this security screening time as compensable. But if the court says the Portal-to-Portal Act does not apply, and then presumably would look to the regulation, I would assume, then I think the question really does become, what is the amount of time that is required by the employer? And again, I don't think that's a factual dispute. We certainly wouldn't want the court to try to wade through the time clock evidence here. But I do think it's important to zoom in on the incremental time that is really due to the mandatory screening itself, rather than the employee's personal choices, which again don't reflect the language of the regulation, and they also don't reflect the declaration of policies, instructions to focus on the fair value of services rendered.
And Counsel Justice Berrigan, I have to try to dig in a little bit. I understand where the amount of time, even given the summary judgment requirements, would go to whether it's de minimis or not. I don't understand how that would go to whether it's compensable as hours worked. It seems to me that that's a legal question, and you could not prevail on that issue, and even prevail at this juncture before us on issue 2. But it seems to me that, as I said, that the first issue before us is a legal issue. Our mandatory screen. I'm looking at the certified question. Time you spent waiting to undergoing mandatory screening compensable as hours worked. We can say yes to that, and then we could conceivably say, however, here it's de minimis, or at some subsequent juncture, some other court, be it the Sixth Circuit, the Western District of Kentucky, could say, well, we have a de minimis doctrine, etc. So again, and I apologize for rambling, my succinct question is, the first question just purely a question of law, regardless of the facts, before you get to the length of time and whether it's de minimis?
I do think it is a question of law, but I worry that if the court answers the unqualified yes without distinguishing between employee A, who spends 8 minutes there, just hypothetically, I'm not saying you should decide employee A on average would spend 8 minutes, but hypothetically, employee A spends 8 minutes rather than 2 minutes that employee B spends, even if they clock out at the same time, because employee A chose to undergo the additional screening lane because they wanted to bring in personal items. That is illegal. That would be an aspect of the legal question, but it would have very broad implications, I think. And I want to dispel the notion that the security screening process here is kind of like a TSA checkpoint. It's closer to the Easy Pass on the Turnpike, where you have a couple of lanes that are dedicated for people who want to move through quickly, and a couple of lanes, like the cash lane, for people who bring in personal items that take longer. But it's an employee choice. And the system here that Amazon has set up that allows employees to decide whether they prefer to leave very quickly through the express lane or prefer to have personal items with them is a choice that should be reflected. Otherwise, you really are treating employees who provide identical services differently in terms of how much compensation they're owed. And that's not just because of the factual question of how long it took on a given day. It really is because you're treating all of the time, regardless of the reasons for that time, as compensable. It looked like there was a question. Yes.
This is Justice Doherty. It will be resolved by putting the timeout clock or the checkout clock at the very end so that all employees, those who use the locker or don't use the locker, could go through the screening required by your company and then clock out. As you indicated, it seems so de minimis, it seems like an easy fix for Amazon.
Well, I think there are two problems with that solution, Your Honor. And the first is that it would lose any differentiation between the employee who didn't bring in personal items and wanted to leave more quickly and the employee who did bring personal items and then spent longer in security screening as a result. And it would really eliminate the express lane option altogether. And this is the second problem because the testimony in the case shows that there is sometimes a backlog at the security screening clock. Now, that doesn't cause a problem in terms of compensability because that time is compensated, but it would create a backlog that would prevent employees who wanted to do so from going straight through the express lane and out the door. There's simply not enough space to have between the security screening and the front door to have another potential choke point without causing a big backlog. And again, you would lose the difference between the employees who brought in personal items and those who avoided doing so and used the lockers.
Mr. Keneally, Todd, can we solve this problem of the standard to apply by just simply adding the word required? Because in your view, they're not required to go through the longer line because they have the choice of putting their personal items in a locker and then having the privilege of going through the express line. So under your analysis, they're not required to go through the longer line, they're choosing to do.
Yeah, I think that would be a good solution. If the court is inclined to adopt the regulatory test, I think that would solve the problem that I'm pointing out. And I do think that's actually where the Vaccaro case that Mr. Weinbrake made reference to in his opening remarks was going in footnote 2, where footnote 2 said, and again, the express lanes were at issue in that case, but we were in a different procedural posture altogether. It was at the pleading stage. And Judge Wolfson noted that the express lane allegations, if proven to be true, may serve to show that Amazon, quote, requires its employees to spend very little time on long security lines. And I think that's where this required test that Justice Todd mentioned would point. But again, we would have to sort that out for sure in front of a fact finder to measure how much is really required. But that would not be an issue for this court. The legal test, I think, at least in that circumstance, would be fairly clear.
Mr. Keneally, could I ask you a follow-up on that? Wouldn't a ruling in the plaintiff's favor incentivize you to streamline these procedures? I mean, you chose to implement them. The employees didn't choose to implement these procedures, so they're of your making, of your creation. Wouldn't a ruling in their favor incentivize Amazon to make them as efficient and swift-moving as possible, with including ways to avoid dilly-dallying?
Well, I think Amazon already attempts to do that. It's not in Amazon's interest to have employees forced to be on the premises longer than they need to be. And that's why, in fact, already Amazon says, please don't bring in your metal items into the workplace. Now, I worry more, and maybe it's abstracting away from Amazon in particular, but if you just imagine a hypothetical employer in the same circumstances, it may be that the incentive then is no personal items on the workplace floor, because then we're going to have a longer screening process. And that really doesn't, I don't think, serve the purposes of the PMWA or really make a lot of sense in any event.
Thank you. Thanks.
Thank you, Your Honor.
We'll answer the certified questions. Take a 5-minute pause and then call the second case.
The next matter is Lamar Advantage versus the City of Pittsburgh. Representing the City of Pittsburgh is Mr. Lawrence H. Baumiller. Representing Lamar Advantage is Mr. Jonathan M. Kamen.
Good morning.
Good morning.
This involves the application of a provision of the Pittsburgh zoning code, which prohibits non-conforming signs from being enlarged or replaced with another non-conforming sign or use. The issue is whether the billboard company needed to obtain city approval before covering an existing electronic advertising sign with a static sign. Mr. Von Miller.
Good morning, Chief Justice Saylor and Associate Justices. May it please the court, my name is Lawrence Von Miller, and I represent the appellants in this matter. In Lamar versus Monroeville, the Commonwealth Court held that a static vinyl sign was different from an electronic sign, and that one type of sign cannot replace another without appropriate municipal approval. Lamar installed the new 7,200 square foot vinyl sign covering the 100-year-old and legally non-conforming 4,500 square foot electronic sign, as well as the entire 7,200 square foot concrete support structure that the old sign was mounted to. This was done without permit application or approval by the City of Pittsburgh. The city issued citations to Lamar, which Lamar appealed to the Zoning Board of Adjustment. The Zoning Board, consistent with Lamar v. Monroeville, the zoning code's definitions of electronic advertising sign, regular advertising sign, and area of sign, found that the 7,200 square foot sign was an illegal change in use and upheld the citations. The zoning code's definition of area of sign differentiates between the extreme limits of the advertising content forming an integral part of the advertising message and the background upon which the advertising content is placed or mounted. This is consistent with the fact that the size of the 100-year-old non-conforming neon tube sign was 4,500 square feet. This is also consistent with the fact that the zoning code defines electronic advertising sign separately from a traditional advertising sign or traditional billboard, and it defines them as different uses with different use regulations, and they're not always necessarily even permitted in the same zoning district. Under the new 7,200 square foot vinyl sign was then certainly a change in use under both the ordinance and under Lamar v. Monroeville. Further, under the applicable standard and scope of review, the zoning board's findings of fact and conclusions of law are afforded great deference.
Counsel Justice Baer, the issue upon which our grant is based, as you framed it, is extraordinarily narrow. You put your hat on the idea that this decision is inconsistent with the Commonwealth Court's decision in Monroeville, and are we not limited to that issue? And that's where you started, and then you seem to diverge as if I don't know, we were the trial court and you wanted to argue the entire panoply of your theories.
Well, Your Honor, we are limited today to the issue that the court did decide to review. But I think it bears mention, and I don't think I went too far afield, but I guess you disagree.
I'm not necessarily. I'm inquiring. Go ahead.
But yes, we are limited to the question that was posed, which was how it was framed by appellants, but it's also the question as certified by this court.
And in that regard, I'm sorry, Justice Donahue, go ahead.
And I'm following up on Justice Baer's question. If we disagree with you as to what the holding in the Commonwealth Court cases that you're relying on, the Monroeville case, is at the end of your appeal. And I will tell you that I do not believe that the Monroeville Lamar advertising case stands for the propositions for which he cited. As a matter of fact, it's diametrically opposed to the situation we have here. What the Commonwealth was dealing with was a new sign that required an entirely new structure, including electronic connections and things of that nature, which they held under circumstances required permitting. We aren't faced with that here. We're the exact opposite of that. We have a situation where no new structure is necessary. All we have is vinyl put up on an existing structure. And frankly, I don't see how the Monroeville case has anything to do with this. So if we should so decide, is that the end of your appeal?
Well, I think that the Monroeville case, and there were some different facts in the Monroeville case, certainly with the new electronics that were required in air conditioning systems. But at the very bottom, what the Monroeville case says is that this is a change in use, and that's enough. And a change in use does not necessarily require a change in structure. For instance, a single-family residence could easily be converted to a fraternity house or a sorority house without any change in structure whatsoever. Same thing when you have a definition of two different uses, an electronic advertising sign and a non-electronic or a traditional advertising sign. You can't just switch from one to the other. It's not the same as switching, advertising copy for Sprint to the National Flag Foundation to Ford. It's.
Why not, Council? Why not? I'm looking at the sections of the code to which you refer, including the the size of the sign and things of that nature, and I don't see anything that actually definitively answers your question. I mean, the city code defines area of sign as the measure, and the measurement includes the frame or other material that's part of the display. I mean, all that happened here is that Lamar put the vinyl over the existing frame. The size is the size under the. I mean, there may be another interpretation of this, but it's clearly not a slam dunk for your purposes. And the certificate of occupancy for this sign indicates that it's 7,200 square feet. So they're just using the 7,200 square feet. So, I mean, unless there's some other specific section of the code that you're referring to, I'm just not certain how we overturn what's happened in all of the lower courts and tribunals that have looked at this.
Well, as the zoning board found, there's the sign itself, which the original electronic sign was 4,500 square feet, which was well defined because it was, an old neon tube sign, which happened to be mounted onto a 7,200 square foot concrete structure. So under the definition of area of sign, you exclude the mounting area. And while the 7,200 square foot concrete structure is somewhat unique to the sign on Mount Washington, if you look at any billboard, a traditional sort of static vinyl billboard, there's typically a billboard structure that is larger than the advertising area of the billboard itself. And does that mean that they can automatically fill that space? Under the city zoning ordinance, depending what district you're in, there's the ASO overlay subsections A and B. The sign can be in urban industrial and general industrial, 750 square feet. But if you're in the urban neighborhood commercial, the UNC district, it's, I believe, 348 square feet. So you can have a larger structure that the sign is mounted to, but the sign face itself is rather limited. And
let me just follow up with one question, and then I'll move on. But where is the evidence in this record that Lamar actually used more than 4,500 square feet of the 7,200 square feet for advertising? Where is it in the record that there wasn't a frame, painted around the vinyl that was put up? I mean, you're asking us to make an assumption that I'm not sure is supported by the record at all.
I believe it was admitted by Mr. Velasic during the zoning board hearing that the vinyl sign was 7,200 square feet.
But that doesn't mean that the advertising was. The code refers to what can be used for advertising.
That's correct. I'm in the record. I'm not. I don't think that there is a photograph of the actual Sprint sign that was there at the time. However, there is testimony from Mr. Velasic as to the fact that the sign, that this new vinyl sign did cover the entire area of not just the original sign, but also the sign support structure behind it.
Mr. Baumiller, can I jump in? And by the way, speaking of behind it, a couple of those books behind you are a lot more fun to read than the ones behind me. But let me ask you, not about the size of the sign, but about a regulation. It appears that the city did not cite Lamar under 919.02.n.6, dealing with replacement of the one kind of sign with the other kind of sign. If that is the case, I think it's the case, and tell me if I'm wrong, then is that a problem for the city here that would have any effect on its ability to argue 921.03F2?
Well, I believe that the city certainly could have been cited under the section that you referenced, changing out one non-conforming sign for the other. But when you are issuing citations for whether under the zoning code or the property maintenance code, it's not necessarily, you don't have to cite someone for every potential thing that you see. You can limit it to what are potentially the larger issues, just to whittle things down, because the main, I believe that they were cited for the main issues in this case, and I know that there is some potential dicta that was in the zoning board's decision, but essentially that issue isn't before the court at this moment.
Counsel, Justice Baer, and I must tell you, because if my vote is, I'm one of seven, I'm often in dissent, and I mean, that's life on our court. But my inclination is to dismiss the appeal as improvidently granted, because, and your argument sort of exemplifies my initial inclination, because I think you don't win the case on Monroeville, and that's all we granted on. What the record reads like, and I mean this respectfully, to the city of Pittsburgh is a fine institution and has fine leadership, but it reads as if for some reason, somewhere in the city, people got angry at Lamar and decided that they were going to punish it with an unnecessary fight. Feel free to comment on that if you'd like to.
Well, Your Honor, I believe what the record supports is that Lamar put up a new sign that they didn't have a permit for, and is and that's kind of the end of the story. Whether there's any,
that's how you tied back to Monroeville.
Yes. Yeah.
Okay. Fair enough. I understand your point. Thank you.
This is a new use, and to reiterate the point that I made before, a new use doesn't necessarily require a new structure or any structure at all.
We understand the argument. Thanks, Mr. Von Miller, and perhaps we could turn to Mr. Kamen.
Good morning, Chief Justice Saylor and Associate Justices and members of the court. I'm Jonathan Kamen, here representing Lamar, and thank you for your time this morning. I wanted to answer a couple of questions that were raised specifically by Justice Donahue and by Justice Weck. In terms of what is legally permitted here on this sign, there is a 1928 Zoning Board of Adjustment decision. There is a 1933 Zoning Board of Adjustment decision. There is a City of Pittsburgh occupancy permit from 1985. all of those support that the area of the sign in this case is 7,200 square feet. Whether I have Chevrolet on that sign or UPMC on that sign, whether it's 16 characters or 4 characters, the number of letters is irrelevant. The area of the sign as permitted by the city is 7,200 square feet. Justice Donahue asked a question as to where is it in the record as to what the size of the sign is. There are photographs showing that the entire face of the sign is covered in neon tubing. That's record pages 176 through 187. There are also pages in the record that show that the entire face of the sign is covered by 20 characters that run the entire face of the sign. That's record 225, 230A, and 330A. The other important piece of this discussion is how this sign was used. This sign had both a daytime read with the name Pittsburgh on it, which many of you may be familiar with. It was rusted. And then it had a nighttime read that had neon tubing that was generated different messages. So over time, there was Iron City Beer on that sign. There was Alcoa on that sign. There was Bayer on that sign. During Bayer's usage of the sign, they not only displayed the logo and the name Bayer, which is what the city is basing the 4,500 square feet on it, they also used to run what they call the Bayer Science Quiz, which generated a number of different questions that would go ahead and be broadcast from the top of the mountain during sporting events. Those various examples of that are also in the record, so you can see that the entire face of the sign was used. If you go back to the question as to area of the sign, if you look at the city's definition in 919.01C16, it talks about the entire area of the sign face, not just the area where the message is displayed, but the background that includes that. And that's included within the 7,200 square feet. And one other point, which I think is critical, which is when we went to go ahead and apply to modernize this sign in 2014, the city charged us $72,000 for that permit, $10 a foot. If it wasn't 7,200 square feet at that time, how can they charge me $72,000 for a permit based on the square footage of the sign? With regard to the distinctions between Monroeville and this case, I tried Monroeville. That was my case. We had to go ahead and pull the sign face off of the existing support structures, in the case either the posts or the beams, and we had to do that with a crane. We had to go ahead and use a crane to install a new sign face. We had to install new electric. We had to install new telecommunications facilities, and we had to install HVAC systems on each of those billboards. That work was the work that was proposed, and that work is the work that the trial court, I should say the Monroeville Zoning Hearing Board, the trial court, and the Commonwealth Court found constituted structural alterations. And if you look at the Commonwealth Court's decision, following up on what Justice Baer said, there are multiple places in the Commonwealth Court decision, page 1003, where they say it's a structural alteration. There's page 1004, where the Commonwealth Court finds that the proposed work is a structural alteration. And finally, on the end of page 1004, it's the Commonwealth Court says that the proposed signage constitutes an alteration of the structure which requires a zoning permit with the site plan and conditional use approval. That's what Monroeville stands for. If I'm altering the structure, I have to go ahead and get a permit. In this case, it's undisputed that there was no alteration of the structure, and you don't have to take my word or Mr. Vlasik's word. You can take Inspector Carmen's word, the gentleman who issued the citation from the city of Pittsburgh, and we cited it throughout our brief, that he said that there was no alteration of the structure and there was no increase in the size of the structure. With regard to Justice Weck's question as to whether the specific sections of the ordinance that were cited and then the new sections of the ordinance that were brought into the zoning board is relevant, it's 100% relevant as to why we shouldn't even be discussing this section N6. The way that this procedural case came up procedurally was it was our appeal from citations issued by the city zoning officer and building inspector. When that happens, the zoning board is only sitting to review the propriety of the action of the zoning officer or code enforcement officer. There were only two sections in front of the zoning board. One, was there a non-conforming expansion of the non-conforming structure? And two, whether the advertising sign had to come down because Bayer had left. Those were the only two sections. What the zoning board did was it went ahead and sua sponte added a bunch of different sections and found in perhaps the most unbelievable decision of my 20 plus years of practicing that the sign had been abandoned. So
could I ask you a question on that, Mr. Kamen? Pardon my interruption, sir.
No.
One of those two sections was 92103F2, right?
Correct. That's the non-conforming one.
You would agree that Lamar ratcheted the vinyl sign to the original sign, whatever its size, right? I mean,
correct.
You had to, so if that was not an enlargement, addition, or replacement under the section, what was it?
It was a change of face, which was exactly permitted under the code. I don't have to get a zoning permit when I'm changing an ad from Chevrolet to Ford. I don't have to get a zoning permit when we change our advertising, whether it's monthly. Lamar has almost 1,000 billboards in the city of Pittsburgh. We annually pay a sign permit fee, which, by the way, substantiates under the code that it's compliant. We paid a sign permit fee for this billboard as well, which the city accepted. That gives us the right to change the sign face in the ordinary course. Again, the critical fact of this sign goes back to its occupancy permit. It's permitted as a ground sign. That means it's not an electronic sign, it's not a static, it's both.
So what is
Sorry.
I'm very sorry, Chief. Just a clarification on that, if I may. What is a replacement then?
A replacement is if I have to take the face of the sign off, like we were doing in Monroeville, or if I have to go ahead and perform a structural alteration, then I have to go for a permit. And in fact, that's what we applied for in 2014, was a permit to make significant structural changes to that sign. If I'm changing the structure, I have to get a permit. That's what the city charged me $72,000 for.
Mr. Kamen, if you were to erect that sign today, pretend there's no sign there, would it be allowed under the Pittsburgh zoning ordinance?
It would not, Chief.
Okay, so you had a non-conforming sign, and there's a provision that says, I think, that an electronic advertising sign shall not replace an advertising sign, and an advertising sign shall not replace an electronic advertising sign unless it meets these requirements. So the problem is it not that this was non-conforming to start with. You're allowed to have the sign, but you didn't change the usage. It's still a sign, but there is this language floating around about changing, whether it's relevant or not, changing it's from electronic to non-electronic. Does that have anything to do with anything? I thought that was the whole point of this.
Well, I'm glad you asked the question. Let me explain it a couple different ways. First of all, this sign is a unique sign in that it has both a daytime read and a nighttime read. The daytime read had Pittsburgh on it, and the name Pittsburgh covered the entire face of the sign. It was done in metal plating, and it has been there since Pittsburgh, probably since the 60s. Prior to that, there was Iron City beer that was on the sign, and that existed for a daytime read. The neon that was on top of that created the nighttime read. And that neon allowed for nighttime messaging to happen from the sign. So this sign has both a daytime static read and a nighttime read, which makes it different from, there's no change here because it has a daytime read and it has a nighttime read. There's
Well, I would
no,
agree, a sign's a sign's a sign, and it's an advertising sign. But there's this language about this shift from electronic to non-electronic or vice versa. And that's the only issue that I'm wondering about.
right, but there was no shift here because the sign had both a static read already and a nighttime read. The issue is that the neon could not be seen during the day. It's just the nature of neon. So that's why the neon could only be seen at night. So that's why the sign has two different reads on it. There was not a change from static to electronic or electronic to static on this particular sign because of the fact that it already had two different reads.
Counsel, may I follow up? It's Justice Donahue.
Yes.
Was your client cited for a violation of the section that the Chief Justice just read to you?
We were not.
You were not.
Correct.
Correct.
Okay, well, I think unless there are other questions, the single issue's been well covered, so we appreciate your advocacy. And again, we'll take about a 5-minute pause before we call the third case of the morning.
Thank you.
The next matter is Commonwealth of Pennsylvania versus James Dwayne Baker Myers. Representing the Commonwealth is Attorney Jacob Charles Sander. Representing Baker Myers is Mr. Douglas E. Straub.
Good morning. This case involves the interpretation of the corruption of minors offense defined in the Pennsylvania Crimes Code. The primary question is whether Aplt's acquittal on all 4 Chapter 31 offenses with which he was charged fatally undermines his conviction of the felony-graded corruption of minors offense. If not, then a follow-up issue is whether the evidence was sufficient to support his conviction. Mr. Sander?
County District Attorney's Office on behalf of the Commonwealth. Justice Saylor, you're exactly correct. And the bulk of my argument is to whether the majority in this case properly applied the decision in Commonwealth versus Magliocco, which again was specifically limited to the ethnic intimidation statute, in finding that the corruption of minors statute, as it relates to the felony offense, requires commission of underlying sex offenses to prove any course of conduct in violation of Chapter 31. We believe that by its very language, the corruption of minors statute is very different and not similar at all to the ethnic intimidation statute. The dissenting opinion by Justice Stabile, I believe, does a fair job in analyzing post-Magliocco decisions, and I just wanted to highlight a couple of those very quickly. The first of those being Commonwealth versus Miller, which the Commonwealth believes is highly persuasive as it relates to the corruption of minors statute. In that case, this court, the Supreme Court, found that the second-degree murder statute does not require conviction of an underlying predicate offense, finding that the term perpetration of a felony is defined very broadly. Well, in this sense, Your Honor, the language, any course of conduct in violation of Chapter 31, is, we believe, equally as broad in this case. So where the second-degree murder statute does not require commission of a predicate offense, neither does the corruption of minors case, corruption of minors offense as it relates to the felony.
Well,
Furthermore,
Counsel, could I ask you, it does require by its terms violation of Chapter 31, right?
Violation of Chapter 31, but it does not state, as the ethnic intimidation statute said, commission. The ethnic intimidation statute requires that someone commits an underlying offense with malicious intent, as I believe the statute says.
Well, what did the jury find was a violation? What's the violation there's the verdict on?
In this case, Your Honor?
Yes.
Well, in this case, Your Honor, I think to look at the jury's determination is to look at the underlying offenses, to look at the testimony in and of itself. Perhaps the jury in this case found, and again, I'm just being speculative here because that's all we can really be in this case is speculative. Perhaps the jury found, based on the testimony, that the act occurred, however, or they could have found that the acts did not occur, that the acts occurred, but perhaps the forcible compulsion or the consent was lacking beyond a reasonable doubt, or that they were perhaps just exercising leniency, as the Superior Court in Commonwealth versus Anderson stated. We just don't know that, Your Honor. We can't invade that sacred province of the jury.
But we do know that there's no jury verdict convicting him of a violation under 31, right?
There's no verdict convicting him of any of the underlying sex offenses, Your Honor, but the Commonwealth's argument is, again, we just don't know what the jury was deciding when they found him not guilty of the underlying sexual offenses of rape, sexual assault, aggravated indecent assault, and indecent assault, but instead found him guilty of that course of conduct. Again, we just don't know what the jury. I'm sorry.
Counsel, Justice Barrett, and I just want to follow up on my colleague's questions. I think he's got his finger on the pulse here. I accept that Magliocco is distinguishable, but I don't think it helps you because you have the burden to prove beyond a reasonable doubt that there's a course of conduct in violation of Chapter 31. I agree with you. The jury may have found that she consented. She's 17, so you don't have statutory assault because you have to be 16 or younger. So tell us because I think it's the whole case, and as I think Justice Wecht is dead on. How did you meet your burden of proof beyond a reasonable doubt that there is a violation of Chapter 31? I think that's the case.
Well, Your Honor, and I think it's very clear based upon her testimony that he touched her in inappropriate ways, had indecent contact with her, digitally penetrated her vagina after removing her clothing, and then in her protest, again, the record is very clear. The record does establish that in terms of her saying that she did not want to do this with the defendant, that she did not, in essence, consent to this, then did penetrate her vagina with his penis. Again, Your Honor, based upon her testimony.
But if I can interrupt again, the jury evidently didn't buy it. It's your burden beyond a reasonable doubt to show a violation of Chapter 31. And I'm not going to be dogmatic or adamant, but if the jury had bought any of that, I think you would have gotten a guilty verdict on something in Chapter 31. If you got a guilty verdict on something in Chapter 31, you're not here.
That's correct,
again, go, and I won't interrupt you again. You go ahead and answer the best you can.
No, Your Honor, and you're exactly correct. But based upon the testimony, a clear reading of that, the Commonwealth believes that we did establish beyond a reasonable doubt all of the elements of the underlying sexual offenses. Why the jury did not find that those offenses were met by the Commonwealth beyond a reasonable doubt, again, is within their province. It could have been easily as they were exercising leniency on a 20-year-old defendant, or it could have been that they said, well, in us listening to her testimony, was she wishy-washy on the fact of, well, maybe she did want to, maybe she didn't want to. Maybe they found that that wasn't, in essence, beyond a reasonable doubt, but still that his actions, in and of themselves, established a violation, a course of conduct that I believe more essentially corrupted the morals of her. How does
the jury verdict support such rank speculation? You fail to convict under Chapter 31, and you want to bootstrap yourself into this statute, which specifically requires you to have a violation under Chapter 31. I don't understand how you're going to support a felony conviction on the basis of after-the-fact speculation about what the jury might have been thinking, notwithstanding the fact you couldn't get the conviction under Chapter 31.
Well, Your Honor, I don't believe that I'm speculating at all in this case. I believe the evidence of the Commonwealth believes the evidence is very clear. Based upon her testimony alone, we believe that the jury could have easily found and determined that he was guilty. Again, why they didn't is within their province. We can no longer speculate on why. That is within what their decision was, and that is what the Superior Court and both the Supreme Court in Commonwealth versus Moore and Commonwealth versus Aikens is said in this case. While they may be logically inconsistent, I agree with that. But logically inconsistent verdicts are still generally approved in the Commonwealth, and I believe that the jury, hearing all of this testimony, can still find the defendant guilty of the course of conduct in violation. That doesn't require the commission, that the jury believe that he actually committed it, but that in a course of conduct, in a violation, any course of conduct, that can mean a number of different things, Your Honor.
Mr. Sanders, it's Justice Todd.
Yes.
I'm sorry, Justice Doherty.
That's okay.
It seems to me, Mr. Sanders, that your best argument is what was outlined by Judge Stabile in the dissenting opinion in the Superior Court, and that is that there was no requirement for any or all of the offenses to be found, a guilty verdict to be found for any of the predicate defenses, as long as the record supported the course of conduct. And I think that's what you're arguing.
That is correct, Justice Todd. What we're arguing is that the evidence in and of itself, while the jury may not have found the underlying sexual offenses were met by the Commonwealth beyond a reasonable doubt, but that they could still say that based upon all of these actions occurring, multiple actions occurring in a span of time, that they could still find that there was a course of conduct in violation, some violation of Chapter 31 that essentially corrupted her morals. That is our argument. And to look at the jury and say, well, this doesn't make any sense. It's logically consistent. The courts, PA appellate courts have found that that is permissible, that is allowable, although they may be logically flawed, like the Miller case was. Logically flawed, still those inconsistent verdicts can be upheld if the evidence supports them, and we believe that the record itself does support those findings.
Okay, Counsel Justice Doherty.
Yes, sir.
Correct me if I'm wrong. My understanding was that the complaint indicated that the purpose for the corruption moral of the minor was quote unquote, to engage in sexual intercourse. Am I correct?
You are correct. You are correct.
So that's the document providing the notice to the defendant. Now, my understanding is that the jury found no offense such that their allegation was that he engaged in sexual intercourse. So the question I have, does it matter whether the complaint cites a predicate offense as opposed to not just, as opposed to saying in violation of Chapter 31? In this particular complaint, it gave the offense of sexual intercourse. Distinguish that for me.
Yes, Your Honor. The information in this case for the corruption of minors offense does state that the acts upon which the corruption of minors statute was based upon in this offense was engaging in sexual intercourse. But the testimony and the evidence that was presented to the jury in this case demonstrated more than simply a singular sexual intercourse. It established the removal of the clothing. It established the digital penetration. It established the exposure of his penis to her. It established the sexual intercourse in this case. And I think the Superior Court in Commonwealth versus Anderson it's sort of a similar offense here, to where in Commonwealth versus Anderson, it was an indecent assault and a corruption of minors as a misdemeanor offense. And the jury found the defendant not guilty of the indecent assault, but still found him guilty of the corruption of minors.
Okay.
Go ahead. I'm sorry.
I based upon your comment, help me unpack this. You're indicating that the description, let's start from the premise that the defendant only had notice that he was being charged with the CMOM as a result of an allegation engaging in sexual intercourse. What you're defining are offenses which may be in violation of section of Chapter 31, but the Commonwealth chose not to provide the defendant with sufficient notice that it may be in violation of Chapter 31. The Commonwealth only gave him notice that he may be in violation of committing sexual intercourse such that he should be convicted of corruption morals of a minor, which did not happen. Explain to me why strategically what you're asking us is the Commonwealth failed to cite in the complaint just the plain language of the statute and instead put a specific predicate act. Why are you now trying to fall back on the expansive quote-unquote violation of Chapter 31 and not quote-unquote engaging in sexual intercourse?
Well,
does that make sense to you?
It does make sense to me, Your Honor. If I may respectfully, I believe the criminal information for the count of corruption of minors, it does state the language in any course of conduct in violation of Chapter 31. And as it relates to the notice that the defendant was given, I think the notice at least are the underlying sexual offenses of the digital penetration, the indecent exposure, the sexual intercourse. So based upon the information, I believe that the defendant did have adequate notice of the course of conduct that we were going to establish. Why the criminal information only stated as the underlying acts were just sexual intercourse, I'm not sure. But I think he did have notice of that, Your Honor.
Counsel, I'm sorry. Go ahead, Chief. Go ahead.
Oh, yeah. Okay. You're aware of the notion that well-established that penal provisions have to be strictly construed. Is that correct?
Yes, Your Honor.
Okay, and the operative penal statute says it's been well mentioned that, put my finger on it, age of 18 years and upwards by any course of conduct in violation of Chapter 31. And there were 4 affirmative convictions or acquittals of the Chapter 31 offenses. Isn't that the beginning and end of the inquiry?
I don't believe so, Your Honor, and respectfully.
I mean, you keep coming back to that theory, but tell me, that's a penal statute.
Yes.
It must be strictly construed. There's 4 Chapter 31 offenses charged. There's 4 affirmative acquittals.
That is correct, Your Honor.
You're going to come back to the same argument. It's just some general course of conduct. Is that it?
Well, yes, Your Honor, and we believe that the language of the statute in and of itself does not require the commission of an underlying predicate offense, but any course of conduct, that could mean any course of conduct outside of what is charged against the defendant in violation of Chapter 31. And they could, I'm sorry.
Counsel, this is Justice Donahue. That's an interesting argument, except that's not how the jury was charged on this count. The jury was specifically charged by the trial court that the sexual offenses were those with which he was charged. He specifically enumerated them: rape, sexual assault, indecent assault, and he was acquitted of all of those. So your notion that there may be out in the atmosphere some other Chapter 31 violation, that's not what the jury was asked to consider.
Well, when I made that argument, I'm making that more of a general in the notion of the statute as a whole in this case. Yes, I agree that the jury was specifically instructed as to the specific underlying offenses that Mr. Baker-Myers was charged with. But again, the province of the jury and the basis for their verdict in this case, Your Honor, is solely within their province. Did they find that perhaps the element of forcible compulsion or consent may have been lacking beyond a reasonable doubt, but still finding that he did commit these certain acts in violation?
But then it's not a violation. I mean, I think that's the point that all of us are trying to make. If the jury concluded that the evidence wasn't sufficient to carry, the burden of finding guilty under those circumstances, then there's no violation. I mean, I think what the problem is here is that this trial court tried to follow a template that they may have seen laid out in Aikens, but the statute at issue in Aikens is very different. That didn't require a violation. That attempted for the purpose of engaging in. So, I mean, they just are not similar circumstances. And I think the trial court did his best, to follow the template that was set out there. But you can't follow that case in this circumstance when you have a statute that explicitly requires a violation. I mean, because you're saying an acquittal means nothing, which is contrary to other case law of this court, which is the acquittal has to mean something. So, I'm sort of hearkening back to the point that Justice Webb and Justice Baer and Chief Justice Saylor made, but it seems that those acquittals are, the nails in the coffin in this argument.
And I certainly understand that, Your Honor. But again, as you relate to case law that states that acquittals are to be given special weight in here, case law, and again, these were cases that were discussed by not only myself, but with Judge Stabile in his dissent, that although a verdict may be logically inconsistent, which I agree, this verdict in and of itself may be extremely logically inconsistent based upon the language, based upon the offenses that were charged, that those inconsistent verdicts can still mean something and can still be and are still generally accepted within the Commonwealth.
Counsel, let me ask it this way, if I could, to follow up on Justice Donahue's question. At 17,000 feet, you have the doctrine of inconsistent verdicts, but coming down lower, drilling down into this case, when the trial judge sent the jury out with instructions on the 4 predicate offenses and then the corruption offense, he didn't also send them out with Title 18 and say, here, rummage through the crimes code. After you deliberate and decide on the 4 predicate offenses, then feel free to rummage through Title 18 and find anything in the Crimes Code that might be a violation according to some ethereal standard. I don't know what the standard is, but I guess you don't think it's beyond a reasonable doubt. And, if that's kind of sort of meets it, then you can return a felony 3 on corruption. If you prevail in this case, what is the rule of law that you propose we issue for all trial courts in criminal cases, at least with respect to Chapter 31? Are juries going to be free to just conjure whatever they think might be in the law beyond what they've been charged on?
Well, no, Your Honor. I think, again, it's a case-by-case basis, but I believe when they are instructed that any course of conduct in violation of Chapter 31, depending on what the offense is charged, what is being presented to the jury, they have to be made aware of that it's not a requirement of the commission of an offense, but as long as the Commonwealth establishes proof of a course of conduct in violation of Chapter 31. We believe that if you relate it to this case, that we believe that the Commonwealth did establish that.
Counsel, if I just might follow up to a logical conclusion here. Under your theory, no defendant has to be charged with any specific violations of Chapter 31, period. And then you have no burden of proof beyond a reasonable doubt as to any of the elements of those particular specific crimes. Under your theory, you could just charge him on the corruption of minors.
Well, Your Honor, Justice Donahue, I believe that's based also upon the language of the statute itself, that there's no requirement of the charging and establishing the commission of a predicate offense, but as long as the Commonwealth establishes some course of conduct in violation of Chapter 31, the jury is free to then find that. If they find that there's been no established course of conduct, they are free then to acquit. I don't believe there's any requirement of it. Now, most Commonwealths and most DA's office will allegedly do that, as done in this case, but I don't believe there's any requirement in that statute. All it requires is that...
How would a defendant defend in that circumstance? Getting back to Justice Weck's point, what do? Hand them Chapter 31 and say, we're going to go at everything that's included in this chapter?
No, Your Honor. It's simply a matter of providing the jury with the information, the specific acts that meet the course of conduct, whether it be digital penetration, whether it be removal of clothing, whether it be indecent assault, or a number of those offenses that the Commonwealth is bringing in on a case-by-case basis. If they are instructed as to this is the course of conduct, this is the nature of the offenses that we believe that the Commonwealth believes supports the corruption of minors as a felony offense, and if you find those beyond a reasonable doubt that they did in fact happen, then you can convict a defendant of corruption of minors as a felony.
Thank you. We'll hear from Mr. Straub.
Thank you, Your Honors.
I imagine your argument will be fairly brief based on the question.
Your Honor, you hit the nail right on the head. I am Douglas E. Straub. I am First Assistant Public Defender for Mercer County. This is my second time before the court. Always a pleasure. I wish it was in person. Hopefully we'll all be back together shortly. I was trial and appellate counsel. Mr. Sanders been involved with the case. We're obviously in front of the Superior Court first. Now we're here. All of the questions the court raised are exactly what we've raised in our brief. They're basically our argument is that this case is Magliocco. This is not a case where we have felony murder issues. This is a case where the overarching offense for which the conviction was found requires as a material element another statutory crime. The court astutely brought up, the justices brought up the information in the case. The information in the case simply alleges sexual intercourse. It doesn't make any reference to any Chapter 31 offense, doesn't make reference to any illegality. It was simply a reference to sexual intercourse between the defendant and the 17-year-old complainant in the case. It doesn't talk about forcible compulsion, lack of consent, or anything. So actually, we believe that that's even a stronger position for us. and that the course of conduct is not alleged but merely a single act, and without reference to the other Chapter 31 alleged offenses, there can be no course of conduct.
Mr. Straub, just so we understand, and that is the case here, and Mr. Sander certainly did the best he can to defend the conviction and secure a dissent in the Superior Court, but as a matter of intellectual curiosity, how about his theory that you could charge the felony, but in the information, describe in support of that felony conduct which, if believed by the jury, would constitute violations of Chapter 31?
Yes, Your Honor. It appears the question will be, how would I have hypothetically drafted the information if I were
would that be sustainable? And I realize that's not the case, but
yeah, Your Honor, I think the justices brought up the point earlier. I think it would have to allege the specific acts. The reason why would be there could be
they have to be separately charged, is my question.
No, I believe it would be justifiable to not charge any of the sexual offenses, but when the information would be drafted to say it is alleged that the defendant, through a course of conduct, to wit, the defendant engaged in non-consensual digital penetration of the alleged victim, engaged in forcible rape of the alleged victim, basically incorporating the very, I guess, succinct allegations of each of the underlying sexual offenses. And again, even if those weren't even charged, and then make an allegation that it was a course of conduct tending to
the candor of that answer. And so the Commonwealth's misstep here was to actually charge for offenses.
Well, yes and no.
But I mean,
yes, Your Honor. I think one of the underpinnings of the case that is a struggle in the case is that the argument that we have the jury going back and deliberating, and we're trying to hypothesize or speculate how they reached a verdict. And ultimately, the gut reaction is to say, well, they did this out of leniency for the defendant. The Commonwealth hasn't proved any of the charges, but we're giving him a break. We think he did all these things, but we can't find that beyond a reasonable doubt. So we're going to give him a break and just find him guilty of corruption of minors. I think the bigger concern is that if you're going to go through that analysis, you also have to look at this and say, well, was this leniency, or is this the thing we really fear a jury might do? May the jury have gotten back to the jury room and said, you know what, they haven't proved any of the offenses. So rather than being lenient and thinking he did all of them, just cutting him a break, so to speak, they say, we don't think he did any of them, but we don't like the way he looks, or this guy seems shady to us, or we thought she was a very nice young complainant. We didn't necessarily what she said, but we have to find him guilty of something because we're here. So the leniency argument is very difficult because, again, we're exercising speculation, and I don't know that you can accurately speculate that it was being lenient versus let's get this person for something.
Counsel, Justice Baer, and just, I'm sorry, go ahead, Justice Todd.
Oh, thank you, Justice Baer. Mr. Straub, 3 members of the Superior Court were not convinced by your argument. And in the opinion by Judge Stabile, those members of the Superior Court concluded that the individual acts demonstrated by the evidence established a course of conduct which met the elements of the corruption of minors statute, and that the particular violations charged, of which he was acquitted, were not predicate offenses. Could you concisely respond to Judge Stabile's opinion?
Yes, I think that the difficulty with that opinion was that the Anderson case is what is relied upon. And I think when the dissenting opinion says that all it is required in this situation is to show acts and that they tended to corrupt the morals of a minor, and then the court relies heavily on the Anderson decision. However, the Anderson decision was decided well before the change in the corruption of minor statutes to allege the Chapter 31 violation. So I think that the dissent's primary misstep was that it was basically reading out completely the language that the acts must be a course of conduct, number one, and they must be in violation of Chapter 31. And the acquittal on those it's fatal because when you're acquitted of the underlying Chapter 31 offenses, now we're getting into the issue of, well, hand us Chapter 31 and let us try to guess another offense that the defendant might have committed to serve as a basis for that. And I just think that we can't do that because those 4 Chapter 31 offenses were the only ones alleged. And they are predicate offenses like we had in Magliocco. There's no ifs, ands, or buts. Once they are charged, the jury obviously did not find beyond a reasonable doubt that any of those 4 were proven. If one of them was proven or 2 of them was proven or he'd been found guilty of 1, 2, or 3 of these, different scenario. But once he's found not guilty of those, we don't have beyond a reasonable doubt on one of the underlying predicate offenses.
So
and that sort of
when you're looking, Mr. Straub, at subpart 2 of the Commission of Corruption of Minors statute, you're saying that the quote, any course of conduct in violation of Chapter 31 does mean that these violations are predicate offenses.
Exactly, Your Honor. And again, that is, you can't escape that language, whether it says course of conduct in violation of Chapter 31 or in the ethnic intimidation commits an offense under. That language to me is a distinction without any significance.
Yeah, except, I'm sorry, finish the answer.
No, that was all, Your Honor.
Justice Baer, and this is in furtherance of Justice Todd's questions, but more specifically going back to the intellectual aspects of what the Chief Justice asked you. One of us has to write this. It seems to me that your responses to the Chief Justice indicate that Magliocco, at least in theory, is distinguishable from this case and is not on all fours. And I just want to try to nail that down. It doesn't mean you don't prevail here, as you can surmise by these questions. In Magliocco, the statute said that the defendant had to commit the predicate crime. So I think what we wrote, and I think we were correct, is that you have to charge and prove the predicate crime to get ethnic intimidation. Here, as you said to the Chief Justice, it would be, it's a law school kind of hypothetical. I don't know that it happens in the real world, but you could charge course of conduct in violation of Chapter 31 as a corruption of minor, not charge any of the other crimes. For instance, you have an 18-year-old boy and a 17-year-old girl, and you know how sympathetic that's going to be to the jury, and so you don't charge that. And put your proof in of all of the facts that you've said and prevail in the case without proving on the record the predicate crime. Now, am I missing something?
If we're talking about the language, we have the language, I've written it down. The Magliocco language is, I believe, commits an offense under. In this case, we're talking about a person doing acts in violation of, and the commits an offense under, and then in parentheses after that, a particular statute versus a commits a violation of a particular set of statutes, Chapter 31. That distinction to me is without any significance. Back to the original question, Your Honor, I think that the Commonwealth does have to allege, in one of the other justices I was having difficulty, but we don't just say corruption of minors because he engaged in certain sexual acts in violation of Chapter 31. And I think Justice Donahue mentioned it, that we don't send the jury out and say, here's Chapter 31, folks, just look through here and see if you see anything that applies. So again, I don't think they have to charge it, but when the judge or when the trial court is giving an instruction, the trial court does have to say it was alleged that this conduct was in violation of this statute of Chapter 31, which is defined as the following, and then say the defendant allegedly did this to the alleged victim, forcible compulsion, did indecent assault, but give the definitions of the offense. But I don't think we can get away from the fact that when the corruption of minors specifically refers to a violation of Chapter 31, in all the Chapter 31 offenses, there's acquittals. And again, if they had alleged...
We understand.
Yes, Your Honor.
I understand the answer. Thank you.
Can I just ask one follow-up question so that I'm clear? When you're responding to, now to Justice Baer, but originally to Justice Saylor, You made the point that it's not necessary to actually charge those predicate offenses, so to speak, but the charge involving a corruption of minors would have to differentiate and specify which specific violations were being alleged. My question is, if it's done that way, would the Commonwealth then still have the burden of proving beyond a reasonable doubt each and every one of those offenses that are now just made part of the corruption of minors as violations of Chapter 31? Violation.
Yes, Your Honor. Again, I think maybe I'm looking more at the practical end of it. In the trial, there might be some sort of change or variance in the evidence that's presented. So I don't know if the Commonwealth would be basically burdened or put at a disadvantage if they alleged 4 or 5 different Chapter 31 offenses and then got to where we're instructing the jury and they said, well, we're going to withdraw, 2 or 3 of these. But I think that we can't get around the fact that there has to be a defined Chapter 31 offense. We can't just say the defendant did an act in a course of conduct which tended to corrupt the minors.
I understand that. My question is much more specific than that. I'll take your hypothetical. They decide to drop certain of the Chapter 31 violations that were originally listed.
Yes, sir.
Whatever remains, they still have to prove that particular violation beyond a reasonable doubt.
Yes, Your Honor. Yes.
Okay, thank you.
Thank you.
Thank you. Thanks to both counsel. We hope things are going well in Mercer County, and we appreciate your checking in with us. So,
thank you very much, Justices.
Thank you, Your Honors.
yeah, we're going to take a break until 12:30 when we'll hear argument in the final case of the day.